If you have been waiting months or even years for your priority date to become current, and you just heard that the February Visa Bulletin brought disappointing news, I want you to know that I understand exactly how you are feeling right now. The frustration of watching dates move slowly or not at all, the anxiety of wondering if your wait will ever end, the confusion about what these numbers actually mean for your future. You are not alone in this. I am here to break down exactly what changed in the February 2026 Visa Bulletin, which countries are most affected, and what this means for your green card journey in clear, simple terms. Please subscribe to Immigration Path USA for the latest updates about immigration news and changes, so you can stay informed with accurate and reliable information. Now let us get into the details of what the Department of State just released in the February 2026 Visa Bulletin, what the numbers actually mean, who is affected, and what steps you can take while you wait. I am going to explain everything in plain language so that by the end of this video, you will have complete clarity about where things stand. First, let me explain what the Visa Bulletin is for anyone who may be new to this process. The Visa Bulletin is a monthly publication released by the U.S. Department of State that tells us which priority dates are currently eligible to proceed with the final steps of the green card process. It is released around the middle of each month and applies to the following month. So the bulletin released in mid-January is the February Visa Bulletin, and it tells us which cases can move forward in February. The Visa Bulletin exists because of a fundamental reality of U.S. immigration law. Congress has set numerical limits on how many immigrant visas, which is another way of saying green cards, can be issued each fiscal year. There are limits on employment-based green cards, family-based green cards, and there are also per-country limits that prevent any single country from receiving more than 7% of the total visas in a given category. Because demand from certain countries far exceeds these limits, backlogs develop, and people must wait for their turn based on their priority date. Your priority date is essentially your place in line. For employment-based cases, it is usually the date your labor certification application was filed, or in some cases, the date your I-140 petition was filed. For family-based cases, it is typically the date your I-130 petition was filed. The earlier your priority date, the closer you are to the front of the line. Now, the February 2026 Visa Bulletin has been released, and I need to share some disappointing news, particularly for applicants from India and China in the employment-based categories. Let me walk you through exactly what happened. For the EB2 category, which includes professionals with advanced degrees and individuals with exceptional ability, the final action date for India has not moved forward from where it was in January. It remains stuck, showing no advancement. For China, there was minimal movement of only a few weeks. For all other countries, EB2 remains current, meaning there is no backlog and applicants can proceed immediately. For the EB3 category, which includes skilled workers, professionals, and other workers, the situation is similar. India saw no forward movement in the final action dates. China saw very limited movement. The dates for applicants from countries other than India and China remain current, or nearly current. For the EB5 investor category, unreserved visas for China are still showing availability, but there are indications that this could change in the coming months. For the reserved categories including rural, high unemployment, and infrastructure, dates remain current for most countries. Now, what does this actually mean when I say no movement or limited movement? It means that if you are from India or China with a priority date that was not current last month, it is very likely still not current this month. If you were hoping that your date would finally become current so you could file your adjustment of status application or proceed to your immigrant visa interview, you will need to continue waiting. I want to take a moment to explain why this happens, because understanding the reason can help reduce some of the frustration. The per-country limit of 7% applies to all countries equally, but the demand from India and China for employment-based green cards far exceeds that 7%. There are simply far more qualified applicants from these countries than there are available visa numbers. This creates a massive backlog that has been building for many years. Some EB2 and EB3 India applicants have priority dates from over a decade ago and are still waiting. This is not a new problem, and it is not something that changes month to month based on government decisions. It is a structural issue built into immigration law that would require congressional action to fix. There have been various proposals over the years to eliminate or modify per-country limits, but as of today, no such legislation has been passed into law. Now let me address some of the misinformation and confusion I have been seeing online about the Visa Bulletin. First, some people are claiming that the government is deliberately slowing down visa processing for certain countries. This is not accurate. The dates in the Visa Bulletin reflect mathematical calculations based on visa number availability and demand. The Department of State and USCIS do not arbitrarily decide to slow things down for specific nationalities. The backlog exists because of the statutory limits set by Congress, not because of processing decisions. Second, some people are saying that if the Visa Bulletin is not moving, it means USCIS has stopped processing cases. This is also not accurate. USCIS continues to process I-140 petitions, and when your priority date does become current, your adjustment of status application or consular processing case will proceed. The Visa Bulletin does not stop processing. It determines when cases can move to the final stage. Third, I have seen posts claiming that certain proposed bills have already changed the Visa Bulletin or eliminated backlogs. As of today, January 19, 2026, no new legislation has been signed into law that eliminates per-country limits or fundamentally changes the employment-based green card backlog. There have been proposals and discussions, but proposals are not law. Until the president signs a bill that has passed both the House and the Senate, the existing laws and limits remain in effect. Fourth, some people believe that if they have an approved I-140, they are safe from any changes and will definitely get their green card. While having an approved I-140 is an important milestone, it does not guarantee a green card. You must still wait for your priority date to become current and successfully complete the adjustment of status or consular processing. If you lose your underlying status while waiting, there can be complications. It is important to maintain valid status and consult with an attorney if your situation changes. Now let me give you some practical guidance based on your specific situation. If you are from India or China with a priority date that is not yet current, the most important thing you can do is maintain your valid immigration status while you wait. If you are on an H-1B, make sure your extensions are filed on time. If you have an approved I-140 that has been pending for more than 180 days, your priority date may be portable if you change employers, but you should consult with an attorney before making any job changes to ensure you do not jeopardize your case. If your priority date is close to becoming current, start gathering your documents now. Collect birth certificates, marriage certificates, police clearances, and medical examination records. When your date becomes current, you want to be ready to file your adjustment of status application or respond quickly to consular processing scheduling. Being prepared can save you valuable time. If you are considering premium processing for your I-140, be aware that premium processing only speeds up the I-140 decision itself. It does not move the Visa Bulletin dates or speed up the overall green card timeline if you are subject to the backlog. Premium processing can be useful in specific situations, such as if you need I-140 approval quickly to extend your H-1B beyond 6 years, but it is not a solution to the backlog problem. If you are filing under EB-1A, EB-1B, or EB-1C categories, you should know that these categories often have better date availability than EB-2 and EB-3. For India, EB-1 dates have historically moved faster than lower preference categories. However, EB-1 has strict eligibility requirements, and you must genuinely qualify. Do not let anyone convince you to file an EB-1 case if you do not meet the criteria, as this can result in a denial and wasted time and money. If you are an EB-5 investor, particularly from China, pay attention to the monthly Visa Bulletin carefully. While unreserved EB-5 has shown availability recently, retrogression can happen, and you want to be aware of any changes that might affect your timeline. The reserved categories for rural, high unemployment, and infrastructure projects have been more favorable, and some investors have chosen these pathways specifically to avoid backlog issues. If you have children who are approaching the age of 21, This is a critical situation that requires immediate attention. Under immigration law, children generally lose their dependent status when they turn 21. There is a law called the Child Status Protection Act that provides some protection by subtracting time from the child's age, but this is a complex calculation that depends on specific factors in your case. If you have a child who may age out before your priority date becomes current, please consult with an immigration attorney immediately to understand your options. Let me also talk about something called the dates for filing chart. Each visa bulletin actually has two charts. The final action dates chart shows when you can complete your green card process and actually receive the visa. The dates for filing chart shows when you may be eligible to submit your adjustment of status application, even if your final action date is not yet current. USCIS announces each month whether they will accept applications based on the dates for filing chart. When they do, this allows you to get your application into the system, receive work and travel authorization, and wait more comfortably even though your final action date is not yet current. Check the USCIS website each month to see which chart they are accepting. I want to remind you that everything I have shared in this video is general information based on the official Visa Bulletin published by the Department of State. This is not legal advice for your specific situation. Immigration cases are highly individual, and the strategy that works for one person may not be right for another. If you have questions about your specific case, your priority date, your options, or any complications, please consult with a licensed immigration attorney who can review your complete situation. I also want to acknowledge that waiting in the visa backlog is emotionally exhausting. Year after year, watching dates barely move, wondering if your career and life are on hold indefinitely. Your frustration is completely valid. Many people in your situation feel the same way. While I cannot change the Visa Bulletin, I can promise to bring you accurate information each month so you understand exactly where things stand and can make informed decisions about your future. The reality is that significant change to the backlog system would require action by Congress. There have been proposals to eliminate per-country limits, increase visa numbers, and recapture unused visas from previous years. These proposals come up regularly and some gain more support than others. But until a bill actually passes both chambers of Congress and is signed by the President, these remain proposals, not law. I encourage you to stay informed about legislative developments, but do not make major life decisions based on bills that have not yet passed. In the coming months, I will continue to break down each visa bulletin as it is released, explain what moved, what did not move, and what it means for you. If there are any legislative developments that actually become law, I will bring you that information immediately. If this video helped you understand the February 2026 Visa Bulletin and what it means for your green card journey, please take a moment to subscribe to Immigration Path USA and tap the notification bell so you never miss an update when new bulletins are released. Give this video a thumbs up because it helps other people in our community find this information when they need it most. Please share this video with your friends, family members, coworkers, and anyone you know who is waiting in the visa backlog. They deserve to have clear, accurate information too. And leave a comment below telling me your priority date, your category, and what questions you have. I read every comment, and your feedback helps me create content that serves you better. Thank you for being here. Thank you for trusting Immigration Path USA to bring you the truth about the Visa Bulletin and immigration news. I know the wait is hard, but you are not alone in this journey. Stay informed, stay patient, and I will see you in the next video.